Judge Whitaker said, while the court does not find that the cited social media post rises to the level of a violation of defendant's probation, it may be prudent for a defendant to exercise restraint regarding certain topics.
Yeah, so that's a little bit of a warning. Hey, get it under control and be aware of what you're tweeting, because remember, when this was retweeted, it launched a bunch of comments, some of which were direct threats against that investigator who was testifying and against the district attorney, Fani Willis. And that's what really prompted Fani Willis to write her motion and say, look, we need to send a clear message that witness intimidation will not be tolerated, and you should throw him behind bars to make sure he learns that lesson. Sounds like the judge said, I'm not going to throw you behind bars over the tweet, but be careful. And that warning shot, that footnote carries a lot of weight, because now he knows going forward what this could prompt, and he doesn't want to be in front of that judge again.
Right. Now he's actually been put on notice as to the type of thing that he shouldn't be doing. And again, why social media? It's just odd to me that he would. Obviously, I get that Doug has a lot of opinions about the DA's office and that RICO case. Dragged on for a long time before he ended up taking that plea deal. But to share them publicly, your views about it, after you struck a deal with that DA's office, it's sort of like walk away clean.
I appreciate, and Charles, by the way, talk about like he has to walk a fine line for a really long time too, because, I mean, it's not like 6 months of probation here.